It offends the rules of procedure, Right Honorable Speaker.
Yes.
The Right Honorable Speaker, according to the official information we have is that the opposition are officially boycotting this sitting. I would wonder how my colleagues are masquerading here.
Honorable. Honorable members, opposition is in the house. Opposition is in the house. I see Honorable Kelo, Honorable Kot, Honorable Olanya, Honorable Santa, Honorable Duru, who was ably presented a report, Honorable Namanya. Honorable members, Legal, did you get a report from?
I've just received a document. Someone came and dumped a document here. But I've just read, it is a minority report of the Honorable Jonathan Odur. I was not informed what it was, but I've just read and realized it is
The man did not attend.
Yes, Fox.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to move a motion.
No, there is still an issue of the minority of Honorable Dor, which the chair said was not given to him.
But, Right Honorable Speaker.
Honorable, yes, yes, Honorable Minister.
Right Honorable Speaker, since NRM believes in democracy, we should allow Honorable Dole present to the House.
Honorable Chris.
Thank you very much, Right Honorable Speaker. We make the rules ourselves as the Parliament, and we must respect our own rules. Anybody to abuse provisions of our rules. If the rules require that a member dissenting must formally process his report, give it a chair, let it be. Let's not allow abuse of our rules. And therefore, if he has not followed what the rules provide for, we should not listen to that report.
Honorable members, let's not be seen to be suffocating in a member. Let Honorable Duru come up with his report and give us a summary of his report, his areas of dissent. Let him do it.
Thank you. Thank you very much, Right Honorable Speaker. Madam Speaker, for the record, this morning, I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk to Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court, at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the shadows approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on sub judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, The time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2, be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025 Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126, 1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3, given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by one Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025 Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it is not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honorable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and Government and Parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the court-martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on restriction on retrospective legislation states as follows. Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two. One in personam and two in rem, to mean against a person and the world at large. In the considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the Supreme Court, the Honorable Lady Justice Catherine Bamugemerere, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I invite members who are still active that when you get children, you can name them after these lordships. And those who cannot get children, when the technology-assisted reproductive law comes in force, you can produce using and name them. One of the best indicators of a progressive democracy is respect for the rule of law, which includes respect for judgments of courts. If this Parliament, in the full glare of right-thinking Ugandans and the entire world, proceeds to disobey the Supreme Court, then this date and year will go down as the official birthday of the dreaded military dictatorship in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This House may have already noticed the following names, in no particular order of chances of being the president, being discussed in the public domain as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mao, Right Honorable Aneta Mao, Colonel retired Dr. Kiza Warren Besige.
Honorable, I've never wished to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker.
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me, since it's a one.
Please, my name is not for jokes. I never want.
Yes, I'm coming.
Honorable, it is my name.
Madam Speaker.
Please remove it.
Yes, this is a one member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to make.
Yeah, withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
To withdraw. I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the record says it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article 92 of the Constitution of the Republic of Uganda in light of the case of the Attorney General versus Michael K. Constitutional Appeal number 2 of 2021. The next point is dissent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, During the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who listed 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offenses, herein called military, disciplinary, or service offenses, stipulated in Part 6 of the UPDF Act. 4, whether civilians can constitutionally or legally be tried in the courts-martial for civil offenses not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5, whether it is constitutional for persons subject to military law to be tried in the court-martial for offenses outside the UPDF Act, herein called civil offenses. 6, whether it is constitutional for civilians to be tried by the court-martial as principal for offenses under sections 1191H of the UPDF Act. Yet all those also exist in the civilian offenses. Right Honorable Speaker, the minority has found it necessary to briefly highlight the decision of the Supreme Court in each of the questions, as this will be extremely important. First, in refreshing the memory of the members. Then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number 1, whether court-martials are courts established under the Constitution or are mere tribunal. In answering this question, Right Honorable Speaker, which answer was agreeable to the rest of the panel, Honorable the Chief Justice, Alphonse C. Owindolo, wrote on page 44, paragraph 15 as follows: I would therefore hold the General Court-Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take-home from this answer is therefore twofold. One is that the Supreme Court recognized the existence of court-martial as a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honorable Minister of Defense, addressed to the following: Honorable Minister of Defense, the Chief of Defense Forces, the Chief of Joint Staff, and Director of Public Prosecutions, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court-Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court-Martial is duly established under the law, and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A, members of the General Court-Martial must be persons with requisite legal qualifications. B, the members of the General Court-Martial should be independent of the command and have security of tenure. C, there should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offenses. D, The convening authority must lie with the General Court Martial, which guarantees institutional independence from the authority prosecuting the case. This is what the Attorney General advised, and it will help us when we come to closes. It is Attorney General further writes, Sections 2, 179, 1191, H and G, now respectively 177, 10X, 1171H and G of the UPDF Act are unconstitutional since they confer blanket jurisdiction on court-martials to try civilians. Our understanding, this is what the Attorney General wrote, our understanding, the understanding of the Attorney General of this declaration 7, 8, and 9 by the court is that civilians cannot be tried in military courts. Our understanding of these declarations 7, 8, and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Article 1193 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government and to give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both the original constitutional petition, number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court, and in the Constitutional Appeal, number 2 of 2021, the Attorney General versus Honorable Michael K. The Attorney General diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even Parliament expect the same learned Attorney General to again go back to the Constitutional Court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be a lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kiwanuka, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they even dare face the same court again on the same issues already decided by court? Finding. And I must say, on a lighter note, Madam Speaker, a former Attorney General William, Senior Counsel William Biarohanga, I'm reliably informed, asked to be excused from executing role of Attorney General. Then another Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this role. He had the energy to marry even a new young wife. So it is really burdensome to be an Attorney General.
Honorable Duru, you're going personal. Please.
I withdraw.
She has nothing. I mean, what's wrong with marrying a wife?
Finding.
Huh?
I withdraw, Madam Speaker. Finding. The minority, therefore, finds that there is no legal basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitutional Court and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify enactment to provide for trial of non-military offenses in the court-martial, and therefore is shallow, unreasonable, and unconstitutional. Court-martials, as found by the Supreme Court, are established legally, hence there is no need to re-establish it. Court-martials, as found by the Supreme Court, and this is what I want members to pay attention to, are already established legally, hence there is no need to re-establish it. The question of restructuring of the court-martial is necessary, but as shall be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next point of dissent. The Honorable the Chief Justice, Alphonse C. Owindolo, in his judgment, found as quoted below. Additionally, I open the quote, additionally, as already noted, the General Court-Martial and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal, number 1 of 2006. However, I do not agree with Mulenga, Justice of the Supreme Court's finding, where he held that the General Court Martial is subordinate, but not lower than the High Court. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placement in or belonging to a lower rank, class or position, or subject to another's authority or control. Assigning the ordinary English meaning to the word subordinate, all courts martials are subordinate courts created under Article 129, 1, sub-article D, and can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than the High Court is contradictory and has potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them jurisdiction to handle capital offenses, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129(1), the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently, by this provision of the Constitution, subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-article 1, and listed either in, you can reflect, in clause 1C with the High Court, meaning at the same level, or immediately before clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, sub-article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martial of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honorable Speaker, The advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honorable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeals sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offenses in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service stroke military offenses must be before civilian courts. In other words, the current civilian courts, Magistrates' Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief, a question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offenses proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offenses. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and will deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers, if we check on the record of the current structure of police, leadership, and the rest, all of them have been recruited by this government. are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power for 39 years, and who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain on the incompetence, weakness in the civil courts to handle any case in Uganda? If the minority was granted more time, Right Honorable Speaker, it would have produced on record all cases of murder, aggravated robberies, terrorism proposed in the bill against accused persons, including military personnel, which has been successfully prosecuted in the civilian courts. By the time of writing this report, Madam Speaker, I had not known that yesterday the High Court convicted a former soldier, a militant, of an offense. That further demonstrates and strengthens my argument that actually the civilian courts right now can convict, try and convict, murder, aggravated robbery, etc. The minority invites the attention of members, especially those familiar with court papers, to reflect on the proposal of the Chief Justice, which captures the spirit of the advisory orders by the Chief Justice as follows. I have put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kampala, the example, and in bracket, we put the provision for court-martial stroke military division. That is what the learned Chief Justice had advised. Finding, the minority finds that the proposals in the Uganda People's Defense Forces Amendment, Bill 2025, purporting to recreate the court-martial with unlimited original jurisdiction is unconstitutional, as it inadvertently amends Article 139 of the Constitution of Uganda without following the procedure of amendment provided under Chapter 18 of the same Constitution. The minority further finds that it is administratively viable to provide for a specialized court within the civilian courts for purpose of trial of criminal offenses committed by the military person. The next point of the dissent is on limited or exceptional circumstances, as it has been said. Madam Speaker, the minority recognizes the discussion in the judgment on the limited circumstances of trials of civilians and or military persons in the court-martial in Uganda. In the judgment, the minority understands that these circumstances appear to be strictly in reference to a situation where, and we can pay attention, one, the Constitution is not in force, similar to the military rule during Idi Amin's regime. That is the first condition for trial of civilians in the military court. There must not be Constitution in force. Two, courts of law have no capacity to try the offenses. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are on duty or deployed in a foreign land where there is no possibility of returning them for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are deployed, so the court martials can try them there in case that country does not have a law or the situation of the war in that country. That is the understanding of the minority. The scenario of Karamoja, which was presented in the committee as a success story of the court martials, was unjustified. It was claimed that judicial officers had feared to be deployed in Karamoja to hear cases because of insecurity. These are the questions. Were other courts in the neighboring districts also unavailable to try those cases? Did the same government demonstrate to Ugandans that courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure law and order in Uganda? And why not deal with the root causes of it all, which is the security of the judicial officers, rather than recourse to the courts martial? Madam Speaker, were the trials free and fair in Karamoja? The presumption of innocence, the charge sheets, were they read through them? Did they take proper plea? Did they give evidence as per the Evidence Act? Was there a ruling on the prima facie case? Was there a defense? Were there the convictions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the minority, it is foolish to legislate to provide for unconstitutional situations, like providing for scenarios where the constitution laws are not enforced. All I am saying, Parliament cannot sit and legislate for a situation where the constitution is not. It would be foolish of us to do that. And as such, to make...
At least not everybody is foolish.
No, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military justice system. First, all Ugandans, Madam Speaker, to make all Ugandans liable for trial in the military justice system. First of all Ugandans must become militants and officers with proper and officers. That first, let's provide for a law for all Ugandans to become militants and officers with proper training in aspect of militarism, with each one of the Ugandans being formally passed out by the Commander-in-Chief, and we are kept, all of us, as the reserve force. The laws of Uganda can then be amended accordingly to provide a concrete basis for such an arrangement. The minority is saying that once all Ugandans are militants, then it is possible to provide for court-martial so that we are all trained and we know we are soldiers. The finding. The minority finds that there are no limited or exceptional circumstances existing in Uganda at the moment, as the constitutional framework and other legislations are in force and they are adequate to deal with all criminal matters before the civilian court. The minority further finds that military disciplinary offenses, as provided in Part 6 of the Principal Act, can be exclusively tried in the court-martial or other disciplinary mechanisms within the command structure of the UPDF. On issue number 2, on whether the courts are independent and impartial within the meaning of Article 28(1) of the Constitution. The answer to this, which the other 6 land justices agreed to, some, albeit with different discussions, is found in paragraph 20 on page 117 of the judgment of Honorable the Chief Justice Alphonse C. Owendolo, whose conclusion is reproduced below. I open the quote. Having regard to what I have discussed above on the issue in the light of the rights to a fair trial enshrined in our Constitution, I find that the safeguards for independence and impartiality of the military court system in Uganda and their procedures for trial do not guarantee a fair trial. It is evident that the General Court-Martial lacks the independence and impartiality required under the Constitution for it to subject the respondent to a fair trial. The observation, Right Honorable Speaker, of the minority is that the principles of the bill and the provisions therein falls short of the findings of the Supreme Court, as there are no procedures for trial. Is it safe? The observation of the minority is that the principles of the bill and the provisions therein fall short of the findings of the Supreme Court, as there are no procedures for trial. When we go to the clauses, I will be asking questions for these procedures to be demonstrated to you. No safeguards for independence and impartiality of the proposed court-martial, which can guarantee the fair trial envisaged by their lordship. On issues 3 to 6, which are summarized here, as to whether civilians can be tried in the court-martial for any offense, and whether soldiers who commit civilian offenses, murder, terrorism, aggravated robbery, cattle rustling, misprision of treason, kidnap with intent to murder. The answer, Right Honorable Speaker, to questions 3 to 6 is found on paragraph 10, pages 142 and 145 of the judgment of Honorable the Chief Justice Alphonse C. Owendolo, who wrote, I open the quote, "The general rule is that ordinary courts alone have jurisdiction to try civilians. I am unable to find any rational or justifiable link between the need to maintain discipline in the army or the maintenance of security of Ugandan borders and the trial of civilians in the military tribunals generally. This position is bolstered further in the light of my finding that trials in the court-martial are devoid of independence, fairness, and impartiality in the conduct of proceedings therein, and the reasons given by the various commissions referred to that discourage trial of civilians by military courts. The result of my finding is that a case where a civilian and a military personnel have committed a crime, both should be tried in the civilian court. When we go into the clauses, I'll be seeking to see how this is provided for. In conclusion, this is what the Chief Justice wrote. The provisions for the blanket trial of civilians in the military courts, either as principles in section 1171H or as accomplices in sections 1171G, does not satisfy the limited or the exceptional requirements of Article 41 of the Constitution. They are unconstitutional. Right Honorable Speaker, the offenses provided in the bill: murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, and cattle rustling have all been provided already in our law books. That is the Penal Code Act. The other offenses in the different pieces of legislation, including traffic offenses, pay attention. The other offenses in the different pieces of legislation in Uganda, including traffic offenses, electoral offenses, wildlife offenses, environmental offenses, etc., that the bill seeks to bring under the unlimited original jurisdiction of the courts martial is irrational. Unless these offenses have been assigned different definitions and ingredients, in which case Parliament will be legislating for a completely new offense, the minority finds no mischief at all in the proposal. In Uganda, if I may elaborate, we have only one offense called murder. There is no first-degree murder, second-degree murder, or third-degree. So the point I'm saying, the offense of murder is already provided for, unless the army wants us to provide for a different set of the murder. Take an example, Madam Speaker. Of the offense of murder under Penal Code Act, all that is required is one, that there is death of a person, a human being. Two, it is unlawfully caused by another person. And three, that the person causing death had malice or intention to kill. Where is the exceptional circumstance in the above offense of murder to warrant a trial before a court martial? Where is the exceptional circumstance in the trial of murder to warrant the movement from the civilian courts? That's the question I'm asking. It is therefore very confusing in the understanding what constitutes an offense of murder in a different way than what is provided already in the Penal Code Act. Right Honorable Speaker, in 2020, at the height of the COVID-19 pandemic, the President wrote a letter accusing members of Parliament of attempted murder when the MPs sought to partake of the COVID bonanza by smuggling 10 billion shillings, which was paid to each MP at 20 million to isolate themselves from the COVID-19 in the lockdown. This points to the fact that there seems to be an understanding by different people of what murder and attempted murder means. And we must be careful to fight for that. The finding: the provisions of the bill on the courts martial falls acutely short of the standards required for fair trials and impartiality envisaged under Article 128 and 128 of the Constitution of the Republic of Uganda and the judgment of Honorable the Chief Justice Alphonse C. Owindolo. Conclusions and recommendations. Madam Speaker, the Uganda People's Defense Forces belongs to all Ugandans. It is a people's army which must not deviate from the aspirations, trust, and respect of the people of Uganda, which is well documented in the report to the Constituent Assembly. And those views, aspirations, were reduced into the provisions of the Constitution of the Republic of Uganda. The UPDF Amendment Bill 2025 is an extremely important bill in as far as, one, provision for the alignment of command, control, and administration, welfare of the officers and the militants, management of the military veterans, management of pensions, gratuities, and compensations of disabilities. The provisions, Right Honorable Speaker, for courts martial in the current substance and form as proposed in the bill are not properly well thought out. They are misconstrued and are extremely dangerous for Uganda, as it seeks to undermine the aspirations of Ugandans as expressed wholly in the Constitution of the Republic of Uganda. Parliament should not allow it to be exploited into being accomplices in overthrowing the constitutional order of Uganda by creating a superior fourth arm of government, the court-martial, which will take over all criminal justice and leave the judiciary with only civil cases. The minority makes the following recommendations to Parliament on the Uganda People's Defense Forces Amendment Bill 2025. 1. That Parliament restricts consideration and the passing of clauses 1. I read. Restricts consideration and the passing of clauses to clauses 1 to 28, clauses 76 and 80 of the bill, which are touching the remedies A, B, C, D, and E, which I've already told you about welfare and etc. of the army. 2. Parliament severs, meaning we, yes. Parliament severs and refers all clauses 29 to 75, 77, 78, 81, and all the schedules thereto back to the executive to comply with the Constitution of the Republic of Uganda and the judgment of the Supreme Court in Constitutional Appeal number 2 of 2021, the Attorney General versus Michael A. Kabaziguruka, and the live reference cases which are right now before the East African Courts of Justice and the Supreme Court of Uganda. 3. That Parliament requires government to table before Parliament the UPDF establishment, which is a regulation made under the UPDF Act for scrutiny to test its conformity to the UPDF Act. The reason is because this entire bill is premised on that document, which we don't have, distributing power, command, and what should happen. So the recommendation is Parliament requires, by whatever mechanisms available, the government to table that UPDF establishment, which is a statutory instrument, it's a regulation, which is made to come here, even if it is not, but it can be enforced. 4. Parliament proposes to the executive to provide all the necessary support to the justice chain actors, that is the police, office of the DPP, and the judiciary, so that they can expeditiously dispose of all criminal cases. Recommendation number 5, that Parliament proposes to government to make special arrangements to facilitate the convening of special court sessions, could be High Court or Magistrates Court, depending on the jurisdiction, for purposes of disposing of all the cases ordered by the Supreme Court to be transferred from the court-martial to the civilian court. Even if it requires the supplementary budget or something, the judges are there, the ODPP is there, the police are there. Give them money so that they can dispose of these cases. 6. Parliament proposes to the executive to respect the rights and freedoms of all Ugandans as enshrined in the Constitution, including rights to belong to political parties of their choices. 7. Recruit, this is if we are inclined, this recommendation number 7, if we think civilians could be tried, this is the proposal. Recruit and train all Ugandans into the military. Arm them with all the items that are a monopoly of the UPDF. And then introduce a law which would then allow every Ugandan to be tried in the court-martial. There, we would have known the guidance of what you should do or not to do in the army. So that when all Ugandans are soldiers and are army, you can then try them. Without prejudice, Madam Speaker, to the recommendations proposed above, should Parliament insist on proceeding on the bill, the minority shall propose amendments to clauses 29, 30, 31, 35, 38, 45, 57, 63, and Schedules 7A and B. Right Honourable Speaker, it is trusted that this Parliament is appointed for the welfare of society and the just government of humanity. And we, the servants who are here assembled right now, are being looked upon with abundant flavor to perform such an important trust of Ugandans. Do not betray that trust. I beg to submit, Madam Speaker.
Thank you. Thank you. Minorities. Honorable Dur, first of all, Honorable Dul, first of all, Article 119, sub-article 3 and 4 gives the Attorney General powers to be the legal advice of government, and where you said I should be the one to answer all the legal requirements or legal questions. I have never been the legal advisor of government. I will now ask the legal advisor of government to respond to all the issues raised in the two minorities, and secondly, on the issues, stop merrymaking, on the issues of sub judice, I can only determine whether there is sub judice when I have been informed of an active civil criminal case, and that is provided for under Rule 75. I will not go on a fishing expedition to find out whether there is a case somewhere, so that can only be answered by the Land Attorney General. Over to you, Land Attorney General.
No, when I was presenting, I made reference to inform the House that I thought it was part of the documents laid by the majority. But now I just beg to lay
Please lay.
The case reference number 14 of 2025 in the East African Court of Justice, First Instance Division at Arusha, Uganda Law Society applicant versus the Attorney General of the Republic of Uganda, who is the respondent. It is duly stamped by the Minister of Justice and Constitutional Affairs, Directorate of Civil Litigation. I beg to lay on table and invite that it's
you can lay it, but I've only gotten to know it now that it is the case. Attorney General, over to you.
Thank you. I refer to the constitutional petition in the application of Malema Birzi. It is already also in the Supreme Court and part of the record, and the Attorney General acknowledged. I just want to set that on record.
Right Honorable Speaker, Honorable Dur has referred to two cases that are in the one case in the East African Court of Justice and another one in the Supreme Court. Right Honorable Speaker, I have had the opportunity to read these two decisions, and I really wonder how someone can actually think it touches on this matter. Because these matters in court, I wonder how we can even think it attaches to the matter before this Parliament. The orders being sought in Malema Birzi are to actually quash. Malema Birzi went to the Uganda Law Society went to the East African Court of Justice to quash the decision of the Supreme Court. So, when you say that we are discussing an amendment, he's not even discussing whether or not you should amend or not amend. He's saying just quash that decision. So if we quash that decision of the Supreme Court, it cannot be a matter that is sub judice, because it will then not even affect the conversation we are having. The second one, Right Honorable Speaker, is a matter of contempt. Honorable Mr. Malema Birzi has taken a matter to the court saying that by the Parliament carrying out this activity of amending the UPDF Act, it is in contempt of court. Right Honorable Speaker, you are damned if you do and damned if you don't, because the Supreme Court did order you to amend the law and bring it in compliance with the decisions of the Supreme Court. That's what we are doing here. Now, for someone to say that we should not do it because we shall be held in contempt, you'll be held in contempt if you don't. So, the conversation we should be having here is whether what we are doing is in compliance with what the Supreme Court ordered. But to say that we should not do it, I think that would be superfluous, and I hope Honorable Dul does agree with me that we must handle this matter. The conversation of what we need to do, what amounts to what is in compliance with the Supreme Court decision, will require us to look at those provisions that are being proposed by the executive, and then we can have a conversation as to whether they comply or they don't comply. But if you say we should not look at them, then you will not even know whether they comply. Right Honorable Speaker, that is my response on the question of sub judice. Then there was a question whether there was a lead judgment Yes, Right Honorable Speaker, I did write under my hand that there was a lead judgment which was given by the Honorable the Chief Justice, but at no point did I even intimate to any member that read only that judgment. You see, when you're dealing with appellate decision, especially where you have 7 justices, you must read all the 7 justices and determine what each one said on that point. You could have a lead judgment where the 6 judges don't agree on a particular point. So I think it is important that as we go through this, I have personally had the opportunity to read all the 7, and I can see you have relied on one judgment, but I think it's important for us to look at all the 7 so that we are clear as to what the court said. The judgment of the lead judgment must be supported by the majority of the other judges on every point that you address. So it is not to say that whatever the lead judgment says must be followed as the final judgment. So, and I think what we have done in this is we have looked at all the judgments and tried to bring them into context. Yes, it is true, Right Honorable Speaker, that I did interpret the decision of the Supreme Court in the letter my learned friend Honorable Odu raised of 3rd February, and yes, I did state that our understanding of the Declaration 7, 8, and 9 of the court is that civilians could not be tried in the military courts. Right Honorable Speaker, Honorable colleagues, the military courts that I was referring to are the ones that exist now. The ones that exist now. If this Parliament is pleased to amend the law and give the military courts the tenets that the court guided us on, the tenets on independence, the tenets on the oath, the tenets on security of tenure, and all those things that we discussed in the Parliament, then I do not think that it will be contrary to the Constitution, because the tenets that are required under Article 128 and Article 28 would be complied with. Right Honorable Speaker and Honorable colleagues, I have not read anywhere in the proposed amendment that the General Court Martial is being given unlimited jurisdiction. Actually, it's being given jurisdiction as set out in the law. So when it says that, for example, you will have the authority to try offenses under any written law, it is the High Court which has unlimited, but some of these offenses are actually tried by magistrates, G1. There are other offenses that are tried by magistrates, chief magistrates, and others are tried by the High Court. When they say that the High Court has unlimited jurisdiction, it just simply says that the High Court can try even that which the G1 can try, but did not say that no one else should try those offenses. So, being subordinate equal, the GCM does not have jurisdiction which is unlimited. So the jurisdiction of any court in this country is granted by Parliament. No, by Parliament. Let me finish so we can have it. Jurisdiction is granted by Parliament. Even the jurisdiction of the High Court, ladies and gentlemen, is granted by Parliament under the Judicature Act. Even the Magistrates Courts Act is one that grants the jurisdiction. If you remember, some time ago, we have started the process of amending the pecuniary jurisdiction of Magistrates Court. That must come to the Parliament. It's not in the Constitution. So the Constitution said there will be these courts, but the granting of jurisdiction is supposed to be granted by Parliament. Yes, it is true, Right Honorable Speaker, that I was asked whether I would trust both courts, and yes, I did say I would trust both, but I think what Honorable Du forgot to answer is that even in our system, we like to go to the professionals in that space first, then go to the generalized courts. We have the electricity disputes tribunals, we have the tax appeals tribunal, we have the industrial court. All those are specialized. Now, in this case, the matters we are dealing with is specialized in dealing with military equipment. I think the profession, the best person who is best professed with the mandate to deal with the military equipment is the Army. So we are saying that when you deal with military equipment and stuff of military nature, deal with the Army first, then come out to the courts, just like we do in other specialized spaces. The GCM, you said that the limited circumstances is where the Constitution is not enforced. No, the Constitution actually told you to make subordinate courts. So we are doing it in accordance with the Constitution. Unfortunately, we are both agreed that this was a matter which even the courts agreed it is a constitutional matter. But you also did point out something where the courts of law have no capacity to try the offenses, for example, shortage of judicial officers. I'll leave that to you members of parliament, because I'm sure every time we come here you talk about backlog and the fact that we need more judicial officers. So that is a matter that you have to have at the back of your mind, whether we should bring more matters to the judiciary. The issue here that we are dealing with, this law does not deal with providing jurisdiction of the GCM over all Ugandans. And therefore, it would not even be necessary for you to get training and get recruited into the army, because the army is not asking for jurisdiction over all Ugandans. It is saying only those who illegally possess killing instruments, which are ordinarily, and I think the issue here is ordinarily they preserve. So if you find yourself in a situation where you find yourself with an AK-47 without a license, and that's what the Army is saying, we may be more specialized. That's what the Army is saying. Minister of Defense said we may be more specialized in dealing with these people who have special skills of acquiring arms illegally. The second one is where you work with the soldiers to commit an offense. But like if a civilian killed someone with a hammer, you don't go to the court-martial. If you kill someone with a hammer, a panga, if you box someone dead, you don't go to the court-martial. They take you to the civilian courts. But if you use the gun, if you use the bomb, then that's what. So it's not that the law is saying all Ugandans must be taken to the court-martial. That needs to be very clear. That is why it's limited in its jurisdiction. Right Honorable Speaker, the procedures that are set out in the law, for example, in the penal code sets out the offenses, but the law on the procedures in courts is the Criminal Procedure Code, the Trial and Indictments Decree. So if you ask me whether the procedure for trials in the court-martial are in the UPDF Act, I'll say no. But there are procedures that are set out for the court-martials. Also, colleagues, we must be clear that the clause 30 and 31 and the clauses that you talk about don't create offenses. No, let me finish. I'll get the clarification after. 117A does not create offenses. 117A is granting jurisdiction. The offense of murder is the same offense in the penal code, and for every Ugandan, murder is the same. There must be a death, but you ask what is the exceptional circumstance here? The exceptional circumstance here is that you committed murder using a weapon which is ordinarily the preserve of the defense forces. That's the exceptional circumstance. Let me finish. I'm going to get the clarification. Just 1 second.
Let me finish.
I think the Minister of Defense will back me up here on this issue of the establishment UPDF. The UPDF establishment is not an instrument. It's a doctrinal document. It's a doctrinal document which is used by soldiers to determine how they relate with themselves. It's not a requirement of the UPDF Act. It's a doctrinal document they use there. So whether or not you should be able to get access to all the documents of UPDF, the Minister of Defense will tell you about that. But this is a tactical doctrinal document. How do we engage? How do we set ourselves up? But the structure of the UPDF is set up in the law, and that's what they're asking Parliament to address. Right Honorable Speaker, I'd like to also address colleagues on the issue of Article 92. Because it was raised in the committee, it was raised severally, and I've had it severally, especially in the first report. The issue is, Article 92 says you should not have a law which has a retrospective effect that would affect the benefits or the decision of a lower court, of a court that has made the decision. Right Honorable Speaker and Honorable colleagues, the Constitutional Court, Supreme Court told us that the members of the UPDF court-martial must be independent and impartial. They told us how they believe the independence and impartiality should be set out. Taking of the oath, we put it in clause 45. Legal qualifications, clause 35, 36, and 38. Manner of appointment is in clause 36, 37, and 38. The term of office, the convening authority is in clause 45. The existence of guarantees of outside pressures is in clause 45. That's what the bill is trying to introduce. Now, it is for members of parliament to look at this and say, do they adequately cover the safeguards that are required of us? Further, we have the bill proposes to introduce the military courts department, which is supposed to be a department which is supposed to be separate and distinct from command and control of the UPDF. And that's the purpose of the act. On the issue of trials of civilians in the court-martial, like I said before the committee, I personally did not find a provision in the decision of the court which said that civilians cannot be tried in the court-martial. And yes, the honorable member was correct. The honorable member was correct that it would be wrong for us to do the same thing which the Supreme Court said we cannot do. And you quoted the decisions of Sri Lanka and London. We have ours here. We have ours here, like the human rights which dealt with POMA, and we have ours here. So we are very alive to those principles. What I can say is that what we are doing here is not at all in pari materia with what the old provisions are. And if members took time off to look at the provisions and look at the differences of the same, I am sure they will agree with me. So, Right Honorable Speaker and Honorable colleagues, those are the questions that I found important, and I've answered them.
Thank you, Honorable.
Let the government put it clearly, for the military attires must be properly designated and labeled as UPDF.
Thank you.
You cannot find somebody put on counter suits and gumboot, you start labeling that this is a military attire, when it's not properly labeled as UPDF military attire.
Thank you.
And finally,
Chairman Sweat.
Honorable Speaker, Right Honorable Speaker, last night I cut Rasala, who came with a gun and killed. On 16th, a Pokot was arrested with a gun in Greek River Sub-County in Soy. Now, there are two scenarios here. Scenario number one is that there was an engagement of the defense forces in the arrest of the criminal who had a gun in Greek River Sub-County. Now, scenario number two was there was a criminal who had recruited himself to the defense forces, and therefore the criminal became a militant, subject to the military court-martial. Now, that again, in the question of Chepskunya Town Council, where a person died, a military officer who was commanding Chepskunya Barracks was again informed that the raiders had come. He rejected and said he is not going to intervene with his force, UPDF, because that role belongs to the police force. Now, what action would the defense forces take against the officer who refused deliberately to take action? Of course, the court-martial would be the best action for this.
Thank you, Honorable.
Now,
yes.
Right Honorable Speaker, there is an issue to do with the military standards. Would be set by the minister through regulations. The standards that the members are asking for are logistical in nature, and it alters procurement and the pricing.
Honorable Guang. Honorable Guang.
Madam Speaker, first of all, I want to stand here and confirm that I'm here to support the majority report which has been presented by the Chair of Defense and Internal Affairs. Number two, Madam Speaker, with your permission, allow me to say the following, colleagues.
Continue.
Madam Speaker, I need to be protected by Honorable Nsereko so that I can make my case.
Honorable Nsereko, why don't you leave your colleague, then you come. Honorable Guang, continue.
Madam Speaker, first of all, I want to address myself to the country on a matter which are regarding the Uganda People's Defense Forces Amendment Bill. I hope the country clearly understands what this amendment is all about. Why am I bringing this? We seem to be only tailoring the bigger picture of the bill to one item which is now discussing about the court-martial. And I want really fellow countrymen and women to first understand the objective of this bill helps us to improve the welfare of our defense forces, which at all times lives to protect this country where we all cherish, whether we are in parliament or not in parliament. However, allow me to address one issue on the minority report. Madam Speaker, and I want to read it verbatim, and it pains, and specifically from my brother, Honorable Jonathan. Madam Speaker, give me 1 minute. The scenario of Karamoja, which I want to quote from his minority view, the scenario of Karamoja, which was presented in the committee as a success story of court-martial, was unjustified. It was claimed that the judicial officers had feared to be deployed in Karamoja as a hear case because of insecurity. And he asked the following questions. My brother, I'm a victim. I am a victim here. If we talk about Karamoja, I am a victim. If you talk about Karamoja, my mother was raped. If you talk about Karamoja, I lost my father. If you talk about Karamoja, I'm still losing people up to now. What are you talking about? When we are here, friends, let's be sincere to ourselves. Some of our people are not sleeping in their houses because of Karachunas who continue to make our people suffer. Friends, this law, this court-martial has helped our people to begin going back to their homes. Friends, our people are now able to go back to their gardens to work because of the court-martial. Where were you at that time when there was no court-martial? Were we not in camps? So when we are here, friends, Honorable Jonathan Odu, our cows left. Where are our cows? Is it Museveni who took our cows or the cattle rustlers? Is it Museveni who helped us now to begin even agreeing to compensate on our cows, which were taken by the cattle rustlers? So friends, when we are here, Madam Speaker, for you to come and insinuate that the court-martial case is not a success in Karamoja is entirely being unrealistic, being not nationalistic, being not a leader of your stature, Honorable Do.
Thank you. Honorable Shaggy.
Thank you. Thank you, Right Honorable Speaker. Right Honorable, if you can protect me from my son here.
The son to the chairman, first wait for the father to speak, then you speak.
If you can allow me to finish. Right Honorable Speaker, the matter we are deliberating is a clear one. And the Attorney General has clarified a number of issues. You know, for us in football, when you are passing, and you get boys or girls playing football with a good talent, we pick them and take them to football clubs. We don't take them to Malua groups, so that their talents are well developed and handled there. So in a situation one is carrying a gun to harm others, terrorize others, the raids which are for military, what is the interest of that person? Do you have to waste time with that person? Take that person where he belongs. Take to the court which it belongs. And now, the issues of independence have been clarified here in this bill, which is so good. In case there are going to be any gaps, we are still here. We shall come back and amend those gaps to make it better and better. Laws are built and made better over time. So, Right Honorable Speaker, I would like now to propose that we constitute ourselves to the Committee of the whole House, and then we debate the clauses. Thank you.
Seconded.
Honorable Speaker,
Maybe when a motion, maybe there is a motion. Let's dispose of the motion first. I'll give you now. I'm going to give you even when we are at committee. I'll give you special consideration. You can. Yes, I'm going to give you. I am going to give you. Honorable members, I am saying I'm going to give you. Why do you challenge my powers? I am going to give you. Honorable members, this has been seconded by Richard, the Prime Minister, Honorable Bahati, Ajat, Honorable both, Ogwa, Gume, by the whole House with the exception of Honorable Duro and Gilbert. You see, Honorable, this morning came to my office and asked for permission. He said he does not have a suit which fits him. Yes, so I gave him permission. Honorable, I'm going to give you to seek for a clarification when it reaches there. I'm going to give you. Yes. Honorable members, that the Uganda People's Defense Forces Amendment Bill 2025 be read a second time. Those in favor say under control and nay. The ayes have it.
The Uganda People's Defense Forces Amendment Bill 2025, Bills Committee stage.
And Madam Chair, thank you very much for your indulgence in this matter. Madam Chair, in the issues of separation of powers, one, and in the issue of administration of justice, we ought to be cognizant of the fact that the investigator cannot be the prosecutor and the judge in the same case. And this is what I'm putting to a servant of justice, the Honorable Attorney General. And secondly, he presents the point of exceptional circumstances in the offenses like that of murder. The Penal Code Act is very clear. Are we setting two standards? When asked, you clearly said we are not setting two standards. It clearly states any person with malice aforethought takes the life of another, commits an offense and is liable to the punishment as prescribed under the law in the Penal Code Act, or commits the offense of murder. Now, the question people would like to be alive to, what is exceptional in the description of that offense? Because an offense that is not well prescribed under the law cannot be charged against someone. The offense must be clear. So when you talk about it being exceptional, can you redefine murder with exceptions? Because the ingredients must be clear, and the Land Attorney General knows exactly what I'm talking about. Maybe Honorable Baliomus is confused. You can clarify.
Honorable Medi, this is under Section 30, Clause 30. This is Clause 30, and I think that it will be clarified when we reach Clause 30. Please read it, Clause 30.
I know the statement. Are we creating a new definition for murder and setting two different standards? And the Honorable do.
Can we handle that when we reach
The Honorable do made that clear.
Clause 1.
Secondly, Right Honorable Speaker, what I've asked for is the issue of the investigator being the prosecutor and also administering justice. Does that answer the recommendations of the Supreme Court?
Madam Speaker, we are debating an important issue to do with the security of the country. We have reached stage 3. We are now on the committee stage.
Honorable Medi, you're going to be the next president of this country. You just need to have patience. You have to be a patient person. You have to be tolerant. You have to listen to all the voices.
Madam Speaker, we are now at the committee stage. We are moving clause
by
clause.
One.
Is in order to do that?
Clause 1.
Clause 1.
Madam Chair, we shared out our roles with my deputy. He presented the report and I'll be presenting the amendments. 4, by substituting for paragraph E the following: any other service
Approve, not prescribing. We can't prescribe. The prescription is operational.
Right Honorable Speaker, we propose to be done has to have the approval of Parliament. The way it's couched here, it is to say that Parliament can sit here and tell UPDF that now you are organized this way.
No, that's operational.
That's operational.
There is no problem. I think the methods of things is they come through a bill and the approval is granted. So even if it remains as it is, I don't think it's an issue. But my amendment on 2, which I put to the committee, is that of the forces prescribed here, one of them is given the word command, which is the Special Forces Command. For uniformity, either we add the word command to the Land Force Command, Air Force Command, Special Force Command, and the Reserve Force Command, or we actually delete the word command, so that the creations is that we have a Land Force, Air Force, Special Force, and then unless there is a justification. And Madam Speaker, my reasoning is that as Parliament we need to understand whether we are creating superiority. And even if the intention is to make the Special Forces Command superior, that is an administrative arrangement, the command, which Parliament does not have to go into. We cannot choose for them the command and etc.
Speaker, this matter was actually raised in the community and was discussed with the UPDF, why they call it a command. And they would like it to remain like this. And I think, so it's just a name, and that's how they would like to have it.
The Special Force is both plead to this House to let it be as it is.
Bill, those in favor say on the contrary, nay. The ayes have it.
Clause 7.
Chair.
We have dropped our amendment and we propose the clause.
Clause 7, Madam Chair, Clause 7 makes provision. We had sought that 1E, which seeks to include members of the High Command, on 26th January 1986, whose names are set in Schedule 3 to this Act, provided that the member has not been convicted for a criminal offense. We had thought that the UPDF is now a people's army. So personalizing it and tying it, Ugandans already moved from the 1986 scenario. That's why the whole army was even renamed Uganda People's Defense Forces. So providing for specific names to put in the law, even as we have been practicing here, I've never seen where we have inserted specific names in the law. And we had proposed that the UPDF has now transited. At that time, Madam Speaker, you could understand the importance of having those generals. But now we have trained very competent army officers who are young, who are refreshed. So we had moved that we can do away with E and delete the members of the High Command as of 26 January 1986 to avoid personal. That's the
Honorable Fox, then Katuntu.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, 3, and we are basically talking about General Salim Saleh and General Matayo Chalagonza. In the High Command, as a historical fact, we are not going to rewrite history. It's our duty to legislate. It's not our duty to rewrite history. Number 2, the Accountants Act that was passed by this Parliament has names of accountants in it. So this is not the first piece of legislation that has names of people in it. So the Honorable Odur ought to know that we have actually passed pieces of legislation where we have listed individuals. And number 3, Right Honorable Speaker, which is the last one.
Honorable, the Pension Act for Speakers names specifically the Speaker. I am also glad that my name has also appeared there.
Thank you very much, Right Honorable Speaker. And lastly, Right Honorable Speaker, this matter was canvassed in the Legal and Parliamentary Affairs Committee and the Defense and Internal Affairs Committee, and we took a position as a majority. It's unfair for the Honorable Dur to reopen a debate that he lost at the committee level.
Thank you.
Only to propose a slight amendment of surviving members of the High Command on the as of the 26th, because as we talk now, the list includes people who are deceased. So we can say surviving members, because we are providing for real membership, and that will include two generals.
Thank you, Right Honorable.
Yes, have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say on the contrary, nay.
Clause 14.
I put a question that clause 14 stands part of the bill. Those in favor say on the contrary, nay. Yes, have it. Part of the bill. Those in favor say on the contrary, nay. Yes, have it.
Clause 17.
I put a question that clause 17 stands part of the bill. Those in favor say on the contrary, nay. Put a question that clause 18 stands part of the bill. Those in favor say on the contrary, nay. Yes, have it.
In under 70B and 70K provides for the minister. Yes, I'm also 19.
We are 19, pension and gratuity.
Yes, and my point was that it is provided for some regulations to be made, which regulation has no input of Parliament. Under 19, I can read because the Attorney General was challenging that it's not there. Under service pensions and gratuity, 70. I don't know whether we have the same bill. In accordance with this Act and regulations made under this Act. So that I wanted that clarification on that particular one. I don't know if the AG has understood me.
The sugar levels are a bit, I beg your pardon. Right, Honorable Chair. It's a common practice that if a proposal like the one that is my good friend Jonathan, Honorable Jonathan Oduri is making, yes, we can make you give us the powers to make the regulations, and we also lay before this Parliament for information and, yeah.
Address yourself to Section 52 of the Parent, 252 of the Parent Act. (252)(2)(a).
Yes, and this specific.
No, it is on regulations.
On
252(a).
The Parent Act?
Parent Act.